This episode covers legal aspects of amending the bylaws for a nonprofit corporation to change its governance, to update the bylaws for changes in the laws, or to conform the bylaw provisions to how the board is actually governing the organization. I'll address the approvals that may be required to amend the governance provisions, how the amendments need to be reported to the IRS and state regulators, and some thoughts on recent developments for emergency governance provisions that nonprofit corporations may want to adopt. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. In previous EO Radio Show episodes, I've talked about some basic governance principles for nonprofit corporations. Before launching into the details of amending the bylaws for a nonprofit corporation, remember that if your nonprofit is created as a trust or as an LLC, these rules may not apply to changes you want to make to your governance structure. Today, I'm going to focus on the basics of amending a corporation's governance provisions in its bylaws. Episode 1 of EO Radio Show gives an overview of nonprofit charitable corporation types. If you want more thoughts on the distinction between nonprofit trusts, corporations, and other forms of entities, listen to that episode as well. Now, remember that nonprofit corporations are fictitious legal entities that are created by filing articles of incorporation, also in some states known as a certificate of incorporation, which is basically a birth certificate for the entity. Throughout this episode, I'll refer to the articles of incorporation rather than the certificate of incorporation, but I'm referring to the same document, that is, the formation document filed with the Secretary of State in the state chosen by the founders of the entity. This formation document for a nonprofit corporation is filed with the Secretary of State in the state the founders choose as the state whose laws they wish to control the internal governance structure of the entity. In most cases, this formation document covers just the bare minimum of the state legal requirements for the corporate entity, although provisions relating to the governance of the nonprofit, such as a requirement for voting members or for control by another entity such as a parent corporation, may be stated there. Amendment of the Articles of Incorporation can be done only by filing an amendment with the Secretary of State, and there are specific mandatory formats which are set out on the website for that particular state where the nonprofit was formed. The nuts and bolts of the governance of most nonprofit corporations is set out in the bylaws rather than in the Articles of Incorporation filed with the state, although some older corporations also included governance provisions in the Articles of Incorporation. So, before amending the bylaws to change or update bylaw provisions, it is essential to look at the Articles of Incorporation first to make sure that the revisions to the bylaws don't conflict with the articles. If they might, unless the Articles of Incorporation are amended as well, the changes to the bylaws may be illegal, ineffective, or confusing, or all of the above. Also, bylaws may not include any provision that conflicts with state law. For example, a bylaw amendment purporting to authorize director voting by proxy would be ineffective because proxy voting by directors is prohibited by corporate law. The next thing to consider is what approvals are needed. If the corporation has voting members, the proposed amendment may require the approval of the voting members. The distinction between the duties and authorities of voting members as compared to directors is covered in Episode 3 of EO Radio Show. In this discussion, when I refer to voting members, I mean only those persons who have voting rights as members under state law, and I'm not referring to non-voting members or to the members of the board of directors. Also, these rules are somewhat different, and there is more flexibility for corporations that are incorporated as religious corporations. So if your nonprofit is incorporated as a religious corporation, check your applicable state law for the bylaw amendment requirements. So back to other nonprofit corporations other than religious corporations. If your nonprofit corporation does have voting members, here are some things to keep in mind as you consider bylaw amendments. Typically, bylaws may be adopted, amended, or repealed by approval of the voting members, which usually means approval by a majority of the members' votes represented and voting in the matter. Unless otherwise stated in the articles or in the bylaws then in effect, the voting membership alone may adopt amendments without the approval of the board of directors. But as a practical matter, most bylaw amendments are first addressed at the board level and then submitted to the voting membership for approval. The following 8 categories of bylaw changes typically require membership approval if the corporation has voting members. First, number of directors. A bylaw amendment specifying or changing a fixed number of directors or changing from a fixed to a variable number of directors, or vice versa, requires membership approval if voting members have been admitted to the corporation. Number 2, membership approval requirements. A bylaw which requires approval by the members or a class of members by unanimous approval, or by a greater proportion than that required by law, can be altered, amended, or repealed only by that specified vote requirement, unless the bylaws provide otherwise. Number 3, increase in directors' terms. A bylaw amendment increasing the length of directors' terms requires membership approval. Number 4, selection of designated directors. A bylaw providing for selection of directors by designation, such as by a national parent entity, can be adopted, amended, or repealed only with voting membership approval. Number 5, replacement of removed directors. A bylaw amendment authorizing the board to fill vacancies created by the removal of directors must be approved by the voting members first. Number 6, members' voting rights. Membership approval is required for any bylaw amendment that would change the number necessary for a quorum at membership meetings, that would create or change member proxy rights, or that would change or repeal cumulative voting rights requires member approval. Number 7, termination of memberships. Termination of all memberships or any class of memberships requires membership approval and is typically subject to special procedures. And number 8, other amendments. The corporation's articles or bylaws may require membership approval of specific bylaw amendments or all bylaw amendments. So those are the 8 categories of bylaw changes that typically require membership approval. Note that class approval is required if a proposed bylaw amendment would materially and adversely affect the rights of a class on voting or transfer in a manner different from the way it affects another class of voting members. For example, a nonprofit corporation might classify its members, such as associate members, junior members, and senior members, with the associate members authorized to elect 2 of the corporation's 12 directors, junior members 4, and the senior members 6. A proposed bylaw amendment that increases the number of directors elected by junior or senior members while leaving the number elected by associate members unchanged would require the approval of those associate members. I want to mention a special point here about mutual benefit corporations, which are nonprofits that are created for the benefit of members. Mutual benefit corporations are different in a number of ways from public benefit or charitable corporations. In the case of mutual benefit corporations, class approval is specifically required for any bylaw amendment that would do any of the following. First, materially and adversely affect the voting, dissolution, redemption, or transfer rights of the class by changing the rights, privileges, preferences, restrictions, or conditions of another class. Second, increase or decrease the number of memberships authorized for that class. Third, increase the number of memberships authorized for another class. Fourth, exchange, reclassify, or cancel any memberships of the class. Or finally, authorize a new class of memberships. So that wraps up the voting member approval requirements for bylaw changes. Now I'm going to turn to a short discussion of board of directors approvals. Board action ordinarily requires a majority vote of the directors present at a meeting at which a quorum is present. However, the articles or bylaws of a particular nonprofit corporation may set higher voting requirements or otherwise restrict or eliminate the board's power to adopt, amend, or repeal the bylaws. The bylaws may also provide that repeal or amendment of any bylaw provision may occur only with the written approval of a specified person other than or in addition to the board of directors or the members. Note also that in corporations with bylaws entitling specific persons to designate directors, the bylaws may require that specific person's approval of any change in those bylaws. Typically here we're talking about a founder, a related corporation, a religious leader. However, unless the bylaws specify otherwise, this approval requirement doesn't continue to apply if the specified person has died or if the office or status that created the right or entitlement has ceased to exist. Once the bylaw amendments have been approved by all the required bodies, that is, the voting members, if any, specified persons, if any, and the board of directors by the required vote, the amended bylaws must be provided to the IRS and to the regulators in the states where the corporation is registered to fundraise or is registered as a tax-exempt entity. For links to the addresses for submitting the amended bylaws, see the show notes for this episode. If the bylaw changes are material, such as removing the governance authority of a supported charity, the nonprofit corporation may also need to submit a formal request for a ruling from the IRS in order to maintain tax-exempt status. In this last section of this episode, I want to mention a few notes about emergency bylaw provisions. Many states have recently updated their corporations laws to give corporations, including nonprofits, flexibility to conduct ordinary business during an emergency, such as a natural catastrophe, an enemy attack, an act of terrorism, or a state emergency declared by the state's governor. These new laws provide certainty to nonprofits so that the board can be confident that their actions taken in good faith during the emergency situation will be effective and will not cause the decision makers to have personal liability for their actions. These laws allow nonprofits to adopt emergency bylaws in advance to manage the ordinary business of the corporation during the emergency. So, if your nonprofit is amending its bylaws and doesn't already incorporate emergency exceptions for governance, you may want to take the opportunity to add these provisions when making other changes. It's likely to be a lot less stressful to the organization to take a fresh look at governance provisions before there's an emergency, and to consider at leisure whether the default provisions of the new emergency governance provisions are desirable or helpful, and whether any other emergency provisions are more appropriate for their circumstances. Note that even without the adoption of these emergency bylaws, many of these state corporation laws provide protections for a nonprofit to permit it to continue its ordinary business during an emergency. Without these rules during an emergency, a nonprofit board might not be able to act or would risk a legal challenge if it acted during an emergency without the approval of a minimum number of required directors. Under typical corporation laws, in the event of a qualified emergency, the board of directors is permitted to relax notice requirements for a board meeting, permit officers to serve as directors in order to achieve a quorum, modify lines of succession, and even relocate the nonprofit's principal business office. However, the laws typically don't allow a nonprofit to take any action that would require a vote of the voting members or that would thwart the actions for which the required vote has already been taken. The nonprofit also can't take any action that's not in its ordinary course of business or exercise emergency powers after the emergency has ended. These corporate laws also authorize a nonprofit to adopt the bylaws to manage its ordinary business during an emergency, so long as these bylaws do not conflict with its articles of incorporation. These provisions can specify procedures for calling a board meeting, quorum requirements for a board meeting, and designation of additional or substitute directors. Corporate action taken in good faith in accordance with emergency bylaws will bind the nonprofit and may not be used to impose liability on the decision makers. On the other hand, a nonprofit may choose to adopt emergency bylaws that require it to conform to the same procedures in effect in the absence of an emergency. In other words, some organizations may want to override the new default emergency powers. And if so, it would be important to put that in the bylaws. So, that covers the key topics I wanted to mention for a nonprofit corporation that is considering amending its governance provisions and the approvals required from voting members, specific persons that have approval rights, and the board of directors. If you are considering amendments, it may be useful to consider also whether emergency default provisions will or should apply. And don't forget to submit copies of the amended bylaws to the IRS and your relevant state regulators. Well, that's it for today. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining me. Until next time, make a difference.